Medical malpractice is a claim that arises from medical treatment that is below the standard of care and causes an injury. If someone is injured as a result of medical malpractice, their entire life can be altered in a matter of minutes. The responsible parties in a medical negligence or medical malpractice lawsuit include the physician or doctor, the nurse, the hospital, the allied healthcare providers that participate in the care of the patient. Sometimes nursing homes are defendants, sometimes care facilities are defendant, sometimes ambulances are the defendants. All of these healthcare providers can be responsible for medical negligence. A doctor that breaches the standard of care is responsible for his error. That doesn't mean a doctor will never make a mistake. Doctors are humans like anybody else, and they make mistakes. Sometimes, however, doctors conduct themselves in such a manner that is so far outside the norm that they are responsible for the injuries that result from those acts. Oftentimes, when we represent victims of medical negligence, we see that our client's mental state is so frazzled and so deteriorated that the patient will never be the same. If a medical malpractice case is successful, our client will recover their special damages, which include all the wages they have lost as a result of the negligence, any medical bills they have incurred as a result of the malpractice, and compensation for their pain and suffering, their mental anguish, and their scarring. Medical malpractice cases are like any other lawsuit. The vast majority of them settle. Here at our firm, we prepare the case as if it's going to trial. We get all the experts together. We get all our exhibits together. We prepare as if the case will go to trial. As we find cases that are ready for trial, will settle for more compensation than cases that are not prepared adequately. I started practicing law in 1987. I worked for a firm that was a national leader in healthcare representations of physicians, hospitals, chains, other healthcare professionals, and I handled many cases from the defense side. When I came to this firm in 1992, I started handling cases on the other side of the docket for injured patients, and I've been doing it ever since. Clients hire our law firm because we are one of the most well-known and established maritime personal injury law firms in the country. Our current and past clients would say that we do everything possible to maximize their recovery. I've made it a practice my entire career to communicate effectively with my clients, and that means returning phone calls, emails, text. I don't let it go overnight. I try to answer the same day, even the same hour. I would say for a personal injury law firm, we're a medium-sized firm. PI firms don't get that big normally. The importance of having a smaller firm is that you get very personal attention. Our law firm is different from other law firms primarily from our level of experience, our level of competence, and our level of professionalism. If a client calls our office seeking advice about whether or not they have a medical negligence suit, usually we'll speak to one of the lawyers who will ask a lot of questions. Those questions will be geared toward determining if there in fact is a case there and what the damage are as a result of the negligence. If we decide to go further with the case, we will ask the client to sign a medical records authorization so we can collect his or her medical records and then have them reviewed by a doctor or nurse to give us more information as to whether or not the acts of the healthcare provider were in fact negligent or malpractice.